Well, hello there, and I do hope you're all well. Now, this is a committee meeting that happened on the same day as our Bodge made a tit of himself at the liaisons meeting, and there was so much to get through that hardly anybody noticed this, because I were doing so much video editing to get through all that. I barely had a chance to get to this one. But anyway, it was headed up by arch Brexiter himself, Bill Cash. And the witnesses were, I've just got these written down so I don't forget, was Barney Reynolds, Head of Financial Institutions, Sherman and Sterling LLP, Professor Alison Young, who's a professor at Cambridge University, and Sir Richard Aikins, Arbiter, Brick Court, Chambers. And this is about the retainment of EU laws and what next, and it was rather quite an interesting conversation. And first question was asked by Bill Cash. It's a bit long-winded, so if I fall asleep and you fall asleep, I do apologise. And but he does get to the crux of his question at the very end. But the reason why I leave what he has to say in is, and he asks Richard Aitken and Alison Young, Professor Alison Young, this, and what they had to say about this question about sovereignty was rather interesting. Enjoy.
I will ask the first question, which is to Sir Richard and Barney Reynolds particularly. In its benefits of Brexit paper, the government says it's looking at how to remove the continued effect of the supremacy of EU law over domestic law, which is the outcome of the legislation that was passed under the Withdrawal Agreement Acts, which were made before the end of the transition period. What do you think is the most effective way to achieve this in terms of legal certainty? And do you have any other comments that you'd like to make about the current state of play in relation to the principles of sovereignty as part of the British constitutional arrangements, because Miller obviously looked at this, but there are a number of other cases that have been well researched over the last 20 years, really. I can think of McCarthy's and Smith, I can think of various other cases where Lord Reid has made judgments. In other words, it's a long-standing question, and there has been some thinking that existed up to Section 38 of the Withdrawal Agreement Act, which has perhaps been underestimated in its effect because of the use of the word notwithstanding in that, by reference in Sections 38 2A and 2B, to the issue, for example, of the directly applicable and the direct effect of EU legislation. So I do think it would be helpful to get your assessment of that, and I'll start, if I may, with Sir Richard Aikins. What is your concept of sovereignty, given, for example, the kind of statements that we saw in the Rule of Law, Chapter 12 by Bingham, which I think is now sort of well known to a lot of people, perhaps not to this audience. Could you just give me your assessment of where you think sovereignty lies?
You could have said that in the first place instead of going around the hedges, round the trees, round the bushes, round the garden and wherever. Jesus Christ. Talk about question getting lost in translation. Jesus. You could have talked to Glassite asleep. Anyway, what these two had to say was very interesting.
I don't think that the concept of parliamentary sovereignty has changed. I think the Dicey principle, if I can call it that, in his renowned work on the Constitution, remains the law. Personally, I don't think there was any need for Section 38 at all. It simply states what the law was and is. So Parliament can do what it likes, so long as it follows the correct procedures in passing acts. it can pass an act to say the world is flat if it wants to.
And believe me, there are plenty of fans all around the globe who believe that.
So I don't see any problem, therefore, about Parliament passing an act, if it wished to do so, legislating on the question of supremacy of EU law as it was. The problem will be that, as things are at the moment, there is no doubt that the courts of this country have to pay attention and have to follow, except in very limited circumstances, existing EU law as it was before the end of the transition period in respect of matters which are retained EU law. But that's a rather more specialist topic which we'll probably want to come on to later.
Thank you very much. I think I'll ask Professor Young and then Barney Reynolds.
Thank you. So I agree that the Dyson principle of parliamentary sovereignty was a long-standing principle and remains and is a long-standing principle of the UK Constitution. I thank you, Chair, for referring.
So much for all that said. We need to leave the evil overlords of the EU to get our sovereignty back.
To the Miller case, both Miller cases reinforced the concept of parliamentary sovereignty as a principle of the UK Constitution. In terms of Section 38 of the European Union Withdrawal Agreement Act 2020, I agree that the purpose of that, in a sense, is to continue to recognise that we have the principle of parliamentary sovereignty in the UK Constitution. That is what the wording of Section 38, subsection 1 specifically says, recognising this. So in a sense, you could say, well, it's not changing the law, so why is it there in a sense? Well, part of why it's there is to reinforce the constitutional importance and constitutional significance of parliamentary sovereignty. And then you have the specific explanations in Section 38, subsection 2 and Section 38, subsection 3 that make it clear that the provisions of the European Union Withdrawal Agreement Act 2020, so Section 38, subsection 2 refers specifically to 7A, 7B and 7C of the 2018 Act. So apologies for all the references to legislation. I'm sure you are following me perfectly.
Importance and clarity as well.
Thank you.
Yes, exactly. Precision is important and clarity is as well. It's a shame that all people like yourself, Bill Cash, who was spouting nonsense about we have to leave the evil overlords of the EU because we want our sovereignty back. And yeah, where was your clarity and precision there, Mr. Bill Cash? Well, what do you expect? How can you trust a man who can't put a tie on without looking like a clown?
So 7A, 7B and 7C are obviously provisions of the European Union Withdrawal Act 2018, and these refer to those aspects of the withdrawal agreement that still have force after IP completion day, and this makes it clear that these provisions exist. So this parliamentary sovereignty exists, notwithstanding this. So Parliament has decided the legal effect that these provisions have after IP completion day, reinforcing the sovereignty in Parliament. And Section 38, subsection C, refers more generally to the fact that nothing in the 2020 Act derogates from the sovereignty of the Parliament of the United Kingdom. So in my reading of this section, it is to reinforce the fact that it is the UK Parliament that determines how retained EU law and how the provisions of the withdrawal agreement and further down, if you go into the future relations agreement, have an effect in domestic law.
I was only going to perhaps put a slight gloss on that, if I may,
Of
or
course.
at any rate to invite you to think about the fact that if you look at all the judgments from Lardner Burke right the way through, we don't need to go into them all now because it would confuse people, but there are so many judgments which have reinforced the points that both of you have made about the intrinsic principle of the sovereignty of the United Kingdom Parliament. However, when you get to the question of whether or not there would be a change in something which had already been enacted, the use of the word notwithstanding has been identified by several, including Denning and others, providing the words are express and clear. So to avoid ambiguity or confusion, and to ensure there is certainty in the manner in which the courts would make the interpretive judgment on a given situation, when you come to the question of the protocol, which is a very vexed question, or indeed parts of the withdrawal agreement, the capacity to override both of those is inherent in the word notwithstanding, providing it's express and clear, which it is. So I just leave that, as it were, on the table, because that is an issue which may yet come up in the lift, we don't know. So I'm now going to move to Barney Reynolds.
And as I say, this is about 10 minutes long now, but I can imagine when he finished his statement, Bill Castro was going to say, whoa, whoa, whoa. Say, God, you want that one? Whoa, I'm a Brexiter. Fucking it. But it just conclusively proves that we never lost our sovereignty. So people like this in Egypt saying stuff that we must leave the evil overlords of the EU because they hate us and they've taken away our sovereignty. Oh, fucking idiot. But anyway, I might do a video where what Barney Reynolds says in another one, because he's a bit long-winded as well, but he has some interesting points. But I shall leave the video, and before I go, I just want to say thank you for 6,000 subscribers. Absolutely stunned, surprised. I never thought I'd ever see this day, but anyway, I just want to say thank you from the bottom of my heart. Never saw it coming. So I shall leave the video here before I babble on and may utter nonsense. And I shall bid you farewell and take care.